Your equity stake has been reassigned to your brother's venture, my father-in-law said, cutting his salmon like he was announcing a weather forecast. Think of it as the family investing in someone with real vision. I set my fork down very carefully. My husband, my soon-to-be ex-husband, though I didn't know that yet, was studying the tablecloth. His mother was refreshing her lipstick in the reflection of her wine glass, and my brother-in-law Ash was grinning at me from across the table with the particular smile of someone who has already won and just wants you to know it. The equity he was talking about wasn't a gift, it wasn't a loan, it was mine. 18% of a SaaS platform called GridFlow that I had spent 4 years building from a whiteboard sketch in our spare bedroom. I had written the original pitch deck at 2 a.m. while my husband slept. I had flown to Denver, to Chicago, to Austin in the same week to close our seed round. I had hired the first 6 engineers. I had named the company. And apparently sometime between last Tuesday and this dinner, it had become ashes. I want to understand what you mean, I said, keeping my voice very flat. My father-in-law. I'll call him Raymond because that's his name and he deserves to have it attached to what he did. Put down his fork and looked at me with the patient expression of a man explaining something to a child who is slow but not unkind. The board met, he said. There were concerns about your leadership trajectory. Ash has a stronger operational background for this stage of growth. The paperwork was filed this morning. It's done, Vera. Vera. That's me. I'm 31 years old. I have a master's degree in computer science from Carnegie Mellon. I had just been told that the company I built had been quietly handed to my brother-in-law while I sat in traffic on the 111. I looked at my husband. He still wouldn't look at me. That's when I understood that this was not a surprise to him. I excused myself to use the restroom. I sat on the edge of the bathtub in Raymond's ridiculous marble bathroom and I called my attorney. She didn't pick up. I texted her 4 words, call me right now. Then I went back to the table and I ate my salmon and I did not cry because I had learned a long time ago that tears at a dinner table only give people like Raymond something to reference later when they want to make you sound unstable. The drive home was silent. My husband, I'll call him Derek, which is also his name, stared at the road. I stared at him. How long have you known? I finally asked. He said, a couple of weeks. I said, and you didn't tell me. He said, they're my family, Vera. That was the last real conversation we had as a married couple. I want to be honest about what happened next, because I've seen versions of this story online where the protagonist is noble and composed the whole time, and that's not what I was. I was furious in a way that I had no framework for. I had married into this family. I had been to every birthday dinner and every Christmas and every tedious 4th of July at Raymond's lake house where he held court about the economy. I had smiled. I had been gracious. I had let Derek's mother correct my pronunciation of certain words without saying a word. And the entire time I was being set up, my attorney called me back at 7 the next morning. I told her everything. There was a pause. Tell me the board composition, she said. Raymond. His business partner, a man named Stratton, who I had met twice, Derek, and a 4th seat that had belonged to me. So they had 3 votes, she said. Yes, I said. And the operating agreement, she said slowly, does it have a right of first refusal clause for equity transfers? I didn't know. I had signed the operating agreement 3 years ago after a long negotiation and I had read every line, but I could not at that moment remember the specific language around equity transfers because I had spent the last 12 hours in a kind of shock that felt like static. Find it, she said, today. I drove to the office, my office, still technically because no one had told HR anything yet, and I pulled the original operating agreement from the filing cabinet behind my desk. I read it standing up. And there it was, in Section 7.4, any transfer of equity to a non-founder party requires written notice to all existing equity holders and a 30-day right of first refusal window. They had not given me notice. They had not given me 30 days. They had filed the paperwork and told me over salmon. I photographed every page and sent it to my attorney. She called me 20 minutes later. They violated the operating agreement, she said. The transfer is voidable. But Vera, be very careful right now. Do not do anything aggressive. Do not tip them off. We need to file before they can restructure. I said, understood. I spent the rest of that day at my desk as if nothing had happened. I took meetings. I reviewed a product roadmap. I answered emails. Ash came by my office in the afternoon, leaning in the doorway with the casual confidence of someone who has already redecorated the place in his head. "No hard feelings, right?" he said. I smiled at him. "Of course not," I said. That night I went home to the house Derek and I shared, and I sat in the kitchen and I made a list. Not an emotional list, a documentation list. Every email, every Slack message, every board communication I could find. I had access to the shared drive. I had access to the board communication folder. And as I went through it, something became very clear. The board meeting where my equity was reassigned had not been properly noticed. Under Delaware corporate law, GridFlow was incorporated in Delaware. Board meetings require at least 48 hours advance notice to all directors unless all directors waive that requirement in writing. I had not been notified. I had not waived anything. I had not even known there was a meeting, but that wasn't the worst of it. As I went deeper into the files, I found a series of emails between Raymond and Stratton dating back 8 months. They were discussing, carefully, in language that was almost but not quite deniable, how to reduce my ownership stake before the Series B. GridFlow had just been valued at $42 million in a preliminary term sheet. My 18% was worth approximately $7.5 million, and Raymond had a problem with that. There was one email that I read 3 times because I couldn't quite believe what I was looking at. Raymond had written, "She doesn't understand the cap table dynamics at this stage. Better to simplify the structure now. While we have operational justification, the investor optics will be cleaner with Ash leading." Investor optics. $7.5 million of my life's work, and the reason it was being taken was investor optics. I kept reading. And that's when I found the document I hadn't known existed. A consent resolution supposedly signed by all 4 board members, including me, approving a restructuring of the equity. My signature was on it. A very good copy of my signature. I had never seen this document before in my life. I sat in my kitchen until 2 in the morning. Then I called my attorney again, even though it was the middle of the night, because there are moments that don't wait for business hours. She picked up. I told her about the consent resolution. There was a long silence. "That's forgery," she said. "Yes," I said. "Do you have the original, the one you actually signed?" "No," I said. "But I know I never signed this one because I was in Seattle on the date on this document. I have a hotel receipt. I have a flight confirmation. I have 3 emails I sent from my laptop at the hotel that evening." She said, "Vera, don't touch anything in those files. Screenshot everything from a personal device, not your work computer. And first thing tomorrow, we're filing for an emergency injunction to freeze the equity transfer." I screenshotted everything. What happened next was the part I wasn't ready for, even though I should have been. By noon the next day, before our filing had even been processed, Derek called me from a number I didn't recognize. His voice was strange and careful. "My father wanted me to let you know," he said, "that they're aware you've been accessing confidential board communications without authorization. They're prepared to allege misappropriation of trade secrets if this goes forward." I said those files were in a folder I had full access to as a board member and co-founder. He said, "You're no longer a board member." I said, "That transfer is legally void and you know it." He said, "Vera, just let it go. You'll get a settlement. Something fair. Don't blow up your career over this." I want to tell you that I laughed. I didn't. I hung up. The trade secret threat was a bluff, my attorney confirmed, but it was a costly bluff because it would take time and money to establish that in court. And time was exactly what they were counting on. Series B term sheets don't stay on the table forever. If they could delay my injunction long enough, GridFlow would close its round with Ash as the lead and my equity would be diluted into something barely worth fighting for. I had to move faster. I had been a founder for 4 years. I knew the investors, not just the current ones, the prospective ones. The Series B lead was a firm called Meridian Capital. I had been in 3 calls with their general partner, a woman named, well, I'll just say she was sharp, and she had a reputation for doing her due diligence properly. I had her direct email from one of those calls. I did not email her yet, but I kept her address in a document I was building. In the meantime, I went back to basics. If the forgery was going to be my strongest argument, I needed to prove it wasn't my signature. I hired a forensic document examiner, a real one, a woman who had testified as an expert witness in federal cases. I overnighted her a copy of the forged consent resolution and 4 genuine samples of my signature from executed contracts over the past 3 years. She came back to me in 72 hours. The signature on the consent resolution was produced with a digital stylus on a touch screen and then printed, she said. The pen pressure pattern is inconsistent with your natural signature. The letter spacing in your first name is wider than all 4 of your comparison samples. This is not your signature. I had her put that in writing. I also, in those same 72 hours, filed a complaint with the Delaware Division of Corporations flagging the consent resolution as a potentially fraudulent filing, and I sent a formal litigation hold notice to Raymond, Stratton, Derek, and Ash, requiring them to preserve all documents related to the equity restructuring. Raymond's attorney called my attorney the same afternoon. They want to talk settlement, my attorney told me. I said, "What are they offering?" She told me, "It was an amount that would have seemed large to me 5 years ago and now felt like an insult engineered to look like generosity." I said no. She said, "Vera, they have resources for a long fight." I said, "So do I now. Tell them I want full restoration of my equity, removal of the forged document from all official filings, a written acknowledgement that the board meeting was improperly noticed, and a formal retraction of the trade secret allegation. Or I take the forensic report to Meridian Capital and explain why their potential portfolio company has a fraudulent filing in its corporate record." There was a pause on my attorney's end. "That last part is aggressive," she said. "I know," I said. She filed it. The response came back in less than 6 hours. Raymond wanted a call, just the 2 of them, his attorney and mine, no clients. My attorney called me after. Her voice was different. "They blinked," she said. "He wants to know if you'll keep it quiet," I said. "He wants to know if you'll keep it quiet," she confirmed. I thought about the 4 years, the 2 a.m. pitch deck, the 3 cities in 1 week, the Christmas dinners where I smiled, Derek's face at that table studying the tablecloth. "No," I said. "We filed the lawsuit the following morning. The complaint named Raymond and Ash individually in addition to the company for breach of fiduciary duty, fraud, and civil conspiracy. It included the forensic report. It included the email chain between Raymond and Stratton discussing the plan. It included the timeline proving I was in Seattle when the forged document was supposedly signed 2 days after the filing became public record. Corporate litigation is public. This is how Delaware works. Meridian Capital quietly withdrew from the Series B. I want to be clear, I did not tip them off. I did not email the general partner. I did not have to. Public court filings are public. Investors read them. GridFlow's board met in emergency session. I was not invited. I was also no longer willing to wait for invitations. My attorney sent them a letter the same day outlining the path to resolution, full equity restoration, dismissal of the trade secret allegation with prejudice, removal of Raymond and Ash from the board pending investigation, and my reinstatement as CEO. Alternatively, we would proceed to trial and make the forensic evidence and Raymond's planning emails part of the public record in perpetuity. I don't know exactly what was said in that board meeting. Stratton, who I'd always privately suspected was smarter than Raymond and more interested in self-preservation, apparently made the calculation quickly. He flipped. He voted to accept the resolution terms. Raymond called me personally that evening. He had never called me personally that evening. He had never called me personally before. I had been his son's wife for 3 years, and he had always communicated through Derek or through assistants or through the table at formal dinners. His voice was controlled, but I could hear something underneath it that might have been fear. "This didn't have to go this way," he said. "You're right," I said. "It didn't. I'd like to think we can move forward professionally," he said. "The equity restoration will take 72 hours to process," I said. "Once I have written confirmation from the Delaware Secretary of State, I'll consider the matter closed on the corporate side. Good night, Raymond." I hung up. Derek texted me that night. Just 2 words, "I'm sorry." I stared at the screen for a long time. I thought about a lot of things. I thought about the person I had been when I met him, 26, and so excited about the future I could barely sleep. I thought about the first time I walked into his family's house and how warm it had seemed, how solid. I thought about how many times I had brushed off small things because I wanted the warmth to be real. I typed back, "I know." Then I turned off my phone and I went to sleep. The equity was restored 11 days after that dinner in Palo Alto. After that dinner at Raymond's house. I drove to my office the morning the confirmation came through, and I sat at my desk and I looked at my laptop screen and I let myself feel it for exactly 5 minutes. Then I opened my email. GridFlow eventually closed a Series B. Different lead investor, better terms, and a board restructuring that removed Raymond entirely. Stratton stayed on, quieter and considerably more deferential. Ash resigned before I had to ask. He's doing something with a podcast now. Derek and I finalized our divorce 8 months after that dinner. It was not ugly. There was nothing left to be ugly about. My attorney sent me a bottle of wine after the equity confirmation. The card said, "Next time, read 7.4 first." I keep the card on my desk. It's good advice for everything. Here's what I know now that I didn't know the night my fork hit that plate. The most dangerous thing you can be to people who underestimate you is patient and organized. Raymond had counted on me being too emotional to read the fine print. He had counted on me being too afraid of the family fallout to fight. He had built the whole scheme on the assumption that the easiest person to steal from is someone who trusts you. He was wrong about all of it. GridFlow is hiring. If you're a good engineer who wants to work somewhere the founder actually understands what you build, you know where to find me. I think about Raymond a lot, not with anger anymore. That burned off a long time ago. I think about him the way you think about a lesson that cost more than it should have. He was a smart man. That's the part people miss when they hear this story. He wasn't reckless. He planned for 8 months. He had lawyers. He had a board. He had a forged signature that was good enough that I had to hire a forensic expert to prove it wasn't mine. He had my own husband in his corner. He had thought through almost everything. What he hadn't thought through was me. And I don't mean that in some triumphant movie poster way. I mean it very literally. He had built his entire plan on a version of me that he had decided on years ago, the daughter-in-law who smiled at Christmas dinner, who let small things go, who wanted the family to work so badly that she would absorb discomfort rather than cause conflict. He thought that woman would take a settlement, sign an NDA, and disappear quietly because the alternative was too loud and too costly and too hard. He was right about who I used to be. He was wrong about who I had become. That's the thing about people who take from you slowly. They don't update their picture of you. They keep seeing who you were when you first let them get away with something small. And that gap between who they think you are and who you actually are, that's where the whole thing falls apart for them. I spent 4 years building GridFlow. 4 years of early mornings and missed weekends and pitches that didn't land, and engineers who quit, and investors who said no and then said yes and then changed their terms. I had been tested in ways Raymond never saw because he only showed up for the dinners. He didn't know what I was made of, because he had never bothered to look. Here's what I learned, and I mean learned in the way that lives in your body, not just your head. Integrity is not just a moral position, it's a strategic one. Every contract I had ever signed carefully, every relationship I had built honestly, every time I had been straight with an investor even when the news was bad, all of it came back to me when I needed it. The forensic examiner trusted her own analysis because I gave her clean comparison samples. The investors at Meridian read the public filing and drew their own conclusions because my professional record gave them no reason to doubt it. Stratton flipped because he had watched me operate for 3 years and he knew when it came down to it which side of this was going to hold. Raymond thought he was stealing a company. What he didn't understand was that the company was only worth what it was because of who I am. You can forge a signature. You can't forge a reputation. Derek texted me, "I'm sorry," and I believed him. I also understood, finally, that sorry is not the same as having chosen differently. The people who love you but don't protect you when it costs them something, they're not villains, they're just not enough. And that's its own kind of loss. Quieter than betrayal, but just as real. I don't carry the story as a wound anymore. I carry it as evidence. Evidence that the most important thing you can build, more important than any company, any valuation, any cap table, is a record of who you are when things are hard. That record is the only thing no one can reassign, no one can forge, and no one can take in a board meeting you weren't notified about. GridFlow is mine. It was always mine. It just took a fight to make that visible to everyone else.